We have one case remaining today's docket, 21-37916, the state of Texas versus Lynn LaSalle. You're Mr. LaSalle. Come on. All right, the defendant is present with his attorney, Mr. Burbank, and the state's attorney. Earlier in this case, the defendant entered a plea of guilty in this case. A pre-sentence report was prepared. Have the parties had an opportunity to review it?
Okay, pause right here. The defendant has already pleaded guilty, but don't let that fool you. This is not just about punishment anymore. Now, it's about how much mercy he can pull from the court or if the judge is even buying what he's selling.
And are there any corrections or changes to it? State?
Nothing state.
And if
Nothing.
then it's made a part of the record for all purposes. The agreement in this case is that whatever sentence shall not exceed a cap of 5 years in prison. So I guess we're looking at no less than 2 nor more than 5 years in prison. I guess deferred or unadjudicated probation is an option. Regular probation, I guess, is an option. Okay, go ahead.
Your Honor, we were here before. We took a recess in reference to some issues. You wanted us to take a look at it. In between that time,
This is some letter of
This is from his new employer, Judge, since the last court date. And he.
Did you catch that? The defense is tossing every option on the table: probation, deferred adjudication, even shock probation. Translation: they are trying to avoid hard time, and fast. But here's the twist. All of that hinges on how credible and sympathetic the defendant looks right now.
Has been hired on as a department head, supervisor at Turbo, whatever, over in Houston. And that's to show that
turbine pump.
right on that. Also, well, Your Honor, I have been in touch with the complainant, and I know what the video shows. It shows that they got into something that he shouldn't have not done. He does have a past, I think, that had come up before in front of you in reference to other instances.
I see a criminal mischief.
Right. And then, well, there was also some family matters that were discussed.
And here comes the emotional balancing act. The defense is admitting fault, but also painting a bigger picture. Family tension, custody concerns, a bad decision fueled by a good motive. Classic move. Shift the narrative from criminal to caregiver. But will the judge buy the reframe?
He still has a young child. He's the primary caregiver over in Houston for she's minor. And it does involve the child and the mother. I think he probably just took the wrong course of action with mom. But he has had continuous, though she says, and I'll be very frank with the judge, she says, well, he's not letting me see her, but he is living over in Houston. I believe she's over here in Beaumont, or in this area, Jefferson County area. But this all started over the care and condition of the child, and that he felt that she was not being taken care of properly.
Who?
The child was not being taken care of properly by mom. There again, I think he took the wrong steps. I think he admitted that he does have a history of kind of taking the wrong steps, and because it's right there in the DSI report that the state and you pointed out the last time we were here. I'd only asked for some consideration in reference that he needs to be corrected and punished. If he goes to TDC, there are more people than him that are going to be hurt.
This line right here, wrong course of action, is doing a lot of heavy lifting. It's legal spin 101, but when a man with a prior record takes justice into his own hands in a custody dispute, that's not just bad judgment, that's a powder keg in a courtroom.
And specifically is the daughter or the child. He does have some other family members that, like today, are taking care of her. But he is the primary and has been taking care of the child. You do have the power of deferred and to review every couple of months or every 6 months or so, or weekends. You know, he is over in Houston, so he have to drive back here to Jefferson County. And then I think we did talk about shock probation, Judge. And it's my understanding for the record that because he has a prior state jail felony, but he would still be eligible for shock probation. Is that your understanding, Mike?
Yes, sir.
But I would just ask that you take it all in consideration. You know, he did what he did, and there's no getting around that. So, if you have any questions of Mr. LaSalle, then I'd be more than happy to answer them, Judge. But I'll represent to the court after the last court hearing. I called Mom at least once, maybe twice.
Here's where it gets real technical. The attorney is banking on shock probation, a sort of legal second chance that kicks in after jail starts. It's rare, it's risky, and it's often seen as a Hail Mary. Judges do not hand it out like candy.
And it wasn't what he did. It was, how am I going to get access to my daughter? That was the whole crux of it. And after advising her, and I will tell you that, well, maybe you should get an attorney or somebody to go out and get a family court order, which they don't have. Maybe it would kind of correct some of this stuff. And I think I went through one ear and out the other. So
The elephant in the room here. A
I
couple of elephants are in the room here.
wasn't going to punch my ticket on that one, Judge.
This isn't the first assault on this lady. You pleaded guilty, I presume, but you were.
All right, grab your popcorn because this is the moment everything bubbles up. When a lawyer starts referencing elephants in the room, you know he's either about to drop something heavy or try to preemptively dodge it.
Convicted, placed on regular probation in 2019 for, let's see, assaulting Jacqueline Frank.